Hi, everyone. This is Eric from hrsimple, and we're happy to present today's webinar, How to Conduct Workplace Investigations. Thanks to all of you for attending the hrsimple.com webinar series. Today's presenter is Ann Kendell of BrownWinick. BrownWinick is the authoring firm of the Iowa Human Resources Manual. Today's webinar is also sponsored by the Iowa Association of Business and Industry. ABI represents a diverse group of businesses, including manufacturers, retailers, insurance companies, financial institutions, publishers and printers, transportation services, law firms, and healthcare organizations. Large or small, urban or rural, each member adds its own particular resources and expertise to the growing strength of the Iowa business community. And in turn, each receives the many benefits ABI membership provides. You can find out more about what ABI can do for your business at iowaabi.org. Okay, a couple quick announcements today. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. We're pleased to announce that hrsimple.com is now an HRCI approved provider as well as a SHRM preferred provider. So at the end of this webinar, we'll give you codes for both of those certifications to get your credit. We encourage you to enter your questions into the chat box, and we'll address them when we can during the presentation. A recording and slides will be made available through email to all registered attendees after this presentation. We're also posting all of our webinars at youtube.com/hrsimple. As I said earlier, today's speaker is Ann Kendell of BrownWinick. Ann serves as co-chair of BrownWinick's Employment Law Practice Group. She practices primarily in the area of employment law and commercial litigation. Ann counsels employers in human resources policies and procedures, unlawful discrimination, harassment and retaliation, whistleblower issues, FMLA, Iowa state and federal wage and hour issues, restrictive covenants, and drug testing policies and procedures, as well as handles employment litigation. She conducts management training concerning drug testing and personnel issues, and has served as an investigator for clients regarding misconduct, discrimination, and harassment allegations. Ann represents her clients in front of administrative agencies such as the Iowa Workforce Development and the Iowa Civil Rights Commission, and in arbitration, as well as state and federal courts. She has had successful jury trials obtaining defense verdicts on sexual harassment, gender discrimination, pregnancy discrimination, and retaliation claims. Ann has also litigated and enforced restrictive covenants on behalf of employers and litigated other commercial disputes. She frequently speaks and writes articles on various employment law topics and is a trained and experienced mediator hired by other attorneys to assist in resolving cases. So as you can tell, we got a great speaker on today. And now I'm just going to go ahead and turn things over to Ann and let her get started.
Thanks, Eric. I appreciate that. One of the things, too, I wanted to mention as we're starting off, as Eric noted in my bio, I've done investigations for clients and actually oftentimes hired by other attorneys so that we can kind of preserve their relationship with their client without having any issues with, privilege. As we want to make sure that we're able to use the investigation in evidence if, unfortunately, we wind up in litigation. So a lot of times I will actually be hiring other attorneys to investigate for my clients. I've been hired by other attorneys to do investigations for their clients. And I've also helped clients do their own internal investigations as well. So I think we all know that these are kind of sticky situations. They're complicated. There are a lot of different angles to view the situation from a business standpoint, a legal standpoint, and obviously dealing with a conflict in the workplace that we need to resolve. One of the first things that I want to address is sometimes when you are the person in the organization that identifies that there is a need to do a workplace investigation, sometimes you may meet with some resistance from people above you, from ownership, etc. Or you might be the one who's questioning, do we really need to do an investigation? And you're talking with your legal counsel, working through that process. There is hesitation and justifiable hesitation with regard to what is perceived as opening a can of worms. And do we really have to do this? I think it's going to be disruptive to the workplace, that sort of thing. So one of the things that I would encourage you as you're evaluating this, as you are considering what options are, needed for your organization, particularly when we're dealing with harassment, discrimination, and retaliation issues, it is important to make sure that we do an investigation and that it is a good and thorough investigation. That is required for purposes of providing legal defenses under the law in those types of scenarios. And quite honestly, it can be very helpful in resolving the matter from a, getting back to business as well as an employee morale situation that you might have. So I would encourage you, when you are meeting with resistance with regard to the possible investigation, it's better to find out what's happening, and it's better to find out the truth and not just kind of phone it in to check it off the box that you did it. It's important to make it a meaningful investigation. Like I said, you may uncover some difficult truths, but it's better to uncover them at that point than to have this revealed as part of litigation against the company and have that result in a large verdict. So just kind of starting off on that note, so what do successful investigations look like? What do they accomplish? Well, successful investigations should be thorough in actuality, and they should look like they're thorough because, of course, if we are using this as evidence, we need to be able to show that it was a thoroughly conducted investigation. A successful investigation should appear, and should be independent or neutral, that the investigator is not going into this situation with a bias or with their mind already made up. And that actually can be a little bit easier said than done. If you have a well-worded, detailed complaint with a very credible complainant, you might go into it thinking, oh my gosh, this is a huge issue. Well, we need to make sure that we're finding out what the truth of the matter is. Or the person who's accused is a long-time employee who everyone likes and respects, and there's never been an issue. There might be, an immediate feeling that that just can't be true. Well, we have our natural human instincts, but we need to make sure that, we maintain that type of neutrality. A successful investigation, it's important, as I noted, to learning the truth and resolving issues. We can't fix something that is going on that is potentially illegal unless we know what's happening. And even issues that don't rise to the level of illegal behavior are still problems. There's still conflict in the workplace, and we need to make sure that we resolve those. Oftentimes, I've done enough defense work for enough years and deposed enough plaintiffs that there are, I would say the vast majority truly believe that they've been wronged. I don't agree that it rises to the level of legal liability, but they're not making it up. They genuinely feel that they have been wronged in some way. And maybe they have been wronged from the standpoint of someone was not very nice to them, not very polite to them, unkind, whatever. But again, not rising to the level of legal liability. The problem is we now have an employer that is spending money on defense costs and dealing with the disruption of having to respond to agency complaints like with the local Civil Rights Commission or the EEOC. And then, obviously, if we're in litigation, we are spending money that we don't want to be spending, and hopefully, will result in a favorable verdict for the defendant, but is still at quite a price. So even issues that truly don't arise to the level of legal liability, that can still be very expensive to win that type of a result. So if we can head issues off earlier rather than later, that's a good thing. Even if the ultimate result is that there wasn't legal liability, we can still try and resolve and do some conflict resolution between two people, manager, subordinate, group of people, whatever the case might be. And there might be legitimate miscommunication, misunderstanding, etc. that's happening. And then lastly, and of course, from the employer's defense attorney standpoint, a successful investigation should help support the employer's defense in litigation. Now, obviously that's a key point, but another thing to consider is that means the person actually conducting the investigation is going to be a key witness. And so when you are deciding, who's going to be that investigator, that is an important consideration. So, what about unsuccessful investigations? Just having an investigation is not the end of the day. We want to make sure that it's a good one. An unsuccessful investigation may leave important issues undiscovered, may leave something under that rug that then blows up later, oftentimes in the course of litigation. That is not a good thing. An unsuccessful investigation may show bias. We've got an investigator who's not listening, not following up, not checking with all the appropriate witnesses, things like that. That can show bias. May damage the credibility of the employer with the involved employees. So we have an investigation, which initially that looks pretty good to the employees that something is happening, the involved employees anyway, because the other ones may not know about it. The problem is if the investigation hurts the credibility, then it just looks like a cover-up. Then the employees actually, I think, get more cynical and to some extent maybe more angry than they were before. So if the investigation starts to look more like a cover-up instead of something that is actually trying to ferret out the truth of a situation, that can backfire. That can actually be worse to some extent than no investigation. So we want to be very careful about that. An unsuccessful investigation may hurt the employer's defense in litigation. And like I just mentioned, if it starts to look like a cover-up, we're losing credibility with our employees. Juries are made up with regular folks just like our employees. And if it looks like a cover-up to our employees and is hurting us in that way, they're mad enough they get an attorney. We have a lawsuit to deal with. It's very possible a jury member might look at that the same way and think this looks like a cover-up and not someone who is trying to handle the situation responsibly. So, because we know our investigator is going to be a key witness and important to this whole process and making sure that this investigation is a successful one, and when I say successful, that doesn't mean we know what the result is. It's successful in that it was all of these other factors that I've just identified. We need to figure out who that person is going to be. This seems like kind of an obvious point, but it should be an uninvolved person. It might be someone who is in human resources and perhaps has had some involvement with some of the people that are involved in a complaint. But if it's not something that is recent or was highly contentious, that it doesn't mean that there has to be no pre-existing history at all. It just needs to be someone who is not going to appear biased with regard to the people that are involved in the situation. We obviously want someone with experience or understanding of investigations. Someone does have to have, a person has to have their first time of doing an investigation. So, obviously it's nice to have someone who's done them before. However, we do want to make sure that, just because someone has never done one, they're not automatically disqualified, but it'd be helpful if they've got, at least some understanding or have had some training in investigations to make sure that it's done well. I've had that situation with some of my clients where we've had someone internally doing the investigation. They know how it works. They've just never done one before, and sometimes we'll kind of help guide them through that. So like I say, if someone has never done one, it doesn't mean they're automatically disqualified. It just means that we want to make sure that they do have understanding of how the process works and has, potentially even has some guidance. Then obviously we want someone with credibility and authority. HR personnel is oftentimes, who is involved in that, or high-level management or ownership. We don't want, just a rank-and-file employee who's, a coworker who has no authority at all doing the investigation. Not that they wouldn't do a good job, but again, this kind of establishes or helps to establish the credibility. So when to hire outside investigators, personally, I pull that trigger pretty quickly. And sometimes, clients will have a little bit of concern about that because, it is an added expense versus having, someone internally do that. In my experience, it's generally been worth every penny because it's a cleaner investigation, at least from appearances standpoint. Not necessarily that an outside investigator is more skilled than anyone you would have internally, but unfortunately, perception is reality a lot of times to employees and to the attorneys that they may be potentially hiring. Oftentimes, it's just there's this automatic assumed bias when we have an internal investigation done. I think that's unfair, but it's just that's the way it goes. It's the way that they're perceived. But we definitely want a situation if there's, history between a party and the HR manager, so the person we would normally be, having do investigations. If there's some sort of, bad blood there, either, personally or professionally, we want to make sure that we're, getting an outside investigator. If the complaint involves the HR manager, of course, then, we need to have someone that is not the HR manager, and again, I would, recommend having, someone from the outside do that. A complaint involving a C-suite executive, someone who's high level. The reason for that is the HR manager or the person who would normally do it is oftentimes the subordinate employee to the person who is the respondent or the person who the complaint is being made about. And that, again, even if there is no pressure, it's still the appearance that how can someone in a subordinate position really thoroughly investigate their boss or someone who's high up in the organization. Maybe not even their boss, but their boss's boss. You can kind of see why that is going to look, it's going to automatically look biased, whether or not the person actually was biased. And then this third or fourth bullet point, this timing and size of investigation, what I'm really getting at there is there may be times where, perhaps the person who would normally do the investigation, say the HR manager, is getting ready to go on maternity leave or is on maternity leave or whatever the case might be. Because of that timing, it makes sense, let's just get an outside investigator. The size of the investigation, if something is revealed that is going to involve lots and lots of witnesses, and we already have an HR manager with a very full load, it makes sense because we want to make sure that we're doing this in a timely manner, that we get someone from the outside to go ahead and get moving on this. That's what I mean by that bullet point. And then other sensitive issues involved. Is there pending litigation? Is there, is this someone who has sued the company in the past. There might be, that's kind of the other category. There might be something that just feels a little awkward about having someone on the inside conduct that investigation. When you have kind of that queasiness factor, I'll say, I think it's important that you look to an outside investigator, because if you are having some concerns about it, then certainly someone else will too. Structure, thinking about the investigation before you get into it, one of the important things is determining the appropriate scope. We'll talk a little bit more about that. We want to determine how we're going to gather the evidence. What are we going to do? Are we going to do in-person interviews, phone interviews? Where are we going to do the interviews? Are we going to be recording or not recording? Those sorts of things. Who's going to be your point of contact to gather, especially if you are an outside investigator, who's your point of contact to get, internal documents from, that sort of thing. Kind of figuring out your strategy on that is helpful. Determining how you're going to conclude the investigation, and that sounds like kind of a strange point, but if you have conducted any investigations, people start telling you lots and lots and lots of things, and some of them seem important, maybe not important to what you're investigating, but important all the same, and figuring out how do we handle that. And then you may have a complainant say they've got 50 witnesses that will say the same thing. Figuring out when you've got what I'll call the critical mass of important or relevant information. That's you could investigate things for years potentially and never end, because you may always have a witness tell you, well, so and so might know this or so and so might know that. So you have to kind of figure out what the end point may look like, as far as do I have enough information to credibly establish that X happened or that X didn't happen. And so thinking about that on the front end can kind of help you. That kind of also goes along with your scope. Now, obviously, you can't set that firm in stone, because you don't know what all you will discover as part of an investigation. But just even having those thoughts on the front end, I think, can be really helpful and help keep you on track and keep you focused. And then determining how you're going to record the results. You may know up front, you may not know up front, but if you have some idea that we're going to need very detailed written report, that will probably kind of help you structure how you are actually gathering evidence. So that's something that is also good to think about on the front end as well. So scope. If you've done investigations, like I said, you will learn lots and lots and lots of things. And again, they might be important, but they're not necessarily relevant to what you're looking into. And you have sort of what we call scope creep. So then it starts to tack on and tack on. So what we want to do is, when we do have a new issue that's raised, we need to first of all figure out, does it play into the underlying issue that we are investigating? Is it important or material to that underlying issue that we are looking at? If it's not, then, and to this second bullet point, we don't want to turn a blind eye or a deaf ear, because it is outside of our scope, but we want to make sure that we note that and allow whoever the decision maker is for the company to know that this was raised, seems like an important issue, and then the company can make a separate decision on how to handle this new piece of information that's come up. So that's what you want to do. You don't want to just ignore that maybe there is some other issue going on that could even potentially be a worse issue than what you're investigating. Again, it might not be part of your investigation, but you let the employer know so that they can make a separate decision on that. So organization, this, like everything, it's important to kind of think about it up front and how you want to keep track of everything. I have seen some people do kind of a log. They'll do sort of an evidence log when they get documents. They'll note what it is, where they got it, the date, that sort of thing. That I think can be very helpful as you're doing it. However you feel most comfortable, kind of keeping track of things, I think makes sense. But you do want to keep some sort of record of all the documents that you gathered and all the documents that you reviewed. So if you looked at some policies, things like that, you want to make sure that you are keeping track of those specific policies. We want to catalog the conversations, keeping track again, what witnesses, who we spoke with, when we did that. Now, remember, our investigator is also a key witness, so we want to make sure that we keep track of about how long did we spend with that person. Those sorts of questions will be asked of the investigator. What day did you meet? What time? About how long did that last? What documents were reviewed with this witness, etc. So we want to have some good and detailed information that we keep with regard to those witness interviews. And then, of course, on the third bullet point, we want to retain all items in a secure location. Just like any other, personnel documentation, we want to make sure that that is maintained in a safe way so that it is not able to be viewed by others. And then on the fourth point, be consistent. We want to make sure, and this is kind of a typical, employment law rule where we want to treat people the same. It's similar, really, with investigations too. We want to make sure that we are doing the same types of things to uncover the same types of, bits and pieces of information and how we're going about that process. So, for example, if you do record interviews, record them all. Or if you don't record them all, have a reason why you didn't. So, for example, if you record interviews and you have one witness say, I'm not comfortable with that and I'm not, I really don't want to be recorded. Okay, you don't have to force that, but now you have a reason why you treated that person differently. And again, like I said, it comes back to sort of that general rule of thumb, why did we do something different? It could play into the, oh, do we not care about some witnesses? Or it could just look sloppy. Either way, it affects, the integrity of the investigation. And so you just want to make sure that you are consistent. So, sabotage. Obviously, if we have documentation problems, if we had documents that we looked at that were important and don't know what happened to them, lost them, that can affect, the support of the conclusions that we've made. Or if you didn't obtain something that seemed important to that, well, why didn't you look at it? Again, it hurts the integrity of that process. Interviews. This is a tough one. We want to be gathering information and not sharing information. We'll talk about some ways to do that, that we try to get more information than we're giving. Sometimes that can be hard because we've got a tough witness that is, just not sharing a lot. Sometimes you have to ask that question just very directly. But on the front end, we want to be careful not to plant seeds of information that a witness may not know. So that is one potential issue. A promise of confidentiality, it really cannot be kept because, as I just mentioned, when we're doing interviews, sometimes we have to ask the direct question that indicates information about who did what to whom. And so right there, you are giving information. So you just really cannot promise to keep things confidential. You can and should tell the complainant and witnesses that, of course, you're going to be as discreet as possible, that we cannot, promise confidentiality because we do have to find out what was happening. But, we cannot make that promise. Delay, and if we do make the promise of confidentiality, we're going to hurt our credibility because we can't keep it. Delay, that obviously can mean a loss of evidence, and that hurts our credibility. It also indicates that we don't care very much, and that perhaps, legal counsel told us, well, you better get an investigation done, and so we're just going through the motions and we don't really care. So that also can hurt credibility. And then, of course, the failure to remain neutral, the actual failure to remain neutral, and then, of course, the appearance that we have failed to remain neutral hurts our credibility and it hurts the integrity of the process. And then, like I mentioned, towards the beginning, that can actually backfire. Instead of, trying to resolve the conflict, it can actually add fuel to the fire. So conducting the investigation, we want to make sure that we are transparent. A lot of times an investigator will get these questions that, or comments. Well, I don't want to get anyone in trouble, so can you promise me that this isn't going to be used against anyone or held against anyone? And in particular, they might be referencing things dealing with other employees, not the person who's been accused of something. They may have to reveal a, violation of company policy to get to the factual scenario of what they saw or heard or whatever. So you can't promise that no one's going to, have any, any consequences. But what you can say is, I'm just here to learn what happened. I can't promise what results will occur. Sometimes you might have the person who made the complaint, say, well, I want this person fired. Can you tell me they're going to be fired? Well, you can't. You're not the decision maker. At least when you are the investigator, you're not in that capacity. It's possible on, the back end after the investigation is done that you might, have some input into it, ultimately results in a termination. But as the investigator, you're not, deciding who is going to be terminated, etc. You are just there to learn what happened and report that back to the company. So you cannot promise, what results are going to come from the investigation. And you should just be upfront about that. Otherwise, afterwards people can just, act like, well, I didn't realize that was going to happen. And, it just can cause real problems on the back end. Making a checklist is a really good idea. A checklist of, what is it that you want to do? Who are the witnesses you need to talk to? What are the things that you need to accomplish as part of this investigation? And that helps just keep you on task. Of course, you want to take notes. Even if you are recording, I would still recommend that you take notes because luckily it has not happened to me, but one of my law partners in years past, was recording and the recording didn't work. So luckily she had also taken notes and that was a good thing. But my point is, I do think you want to make sure that you take notes. There could be some audio trouble, or like we've had here, or perhaps something happens to that recording and it's lost. So it's a good thing to take notes. You can take notes during the investigation or during the interview, but I would also make sure that you maintain eye contact with the witness, because you can really learn a lot about the witness. You can judge their credibility by watching them. It also helps develop rapport with someone when you are having good eye contact with them. So try not to let the notes interfere with your ability to observe the witness, but do take notes all the same. After the witness interview is done, at that point, I try to schedule time after every interview to then go back through and fill out my notes more completely after that's over. Also may help you find, some spots that you want to follow up on, that sort of thing. But you can take notes during, definitely, then fill out more notes afterwards. But the key thing is, don't just rely solely on recordings, even if you are recording interviews. Prepared comments can help ensure consistency. I don't care how many investigations you've done, there's always a level of awkwardness because you're asking someone who's very nervous questions, and questions that might be uncomfortable questions. So it's very helpful I find, to kind of type up your introductory comments. If you are an internal person, you don't need to introduce yourself because they already know you, but you will still have introductory comments. If you are not known to the witness, then of course you want to make sure that you introduce yourself. Some of the key comments that you want to have, said with every witness are the fact that the company prohibits retaliation and that it needs to be reported immediately. So those are the sorts of things that I think can be, really helpful, to just have, kind of your standard language that this is what you say. And again, this helps with consistency. You said it to every witness, then every witness got that same note about, the fact that there should be no retaliation and that should be reported immediately. That is just, I think it's just very helpful to kind of already have those bullet points, or if you like to have it scripted specifically, having that all, prepared is just very helpful. So starting the actual interview, you've got, a good, quiet, location where you can have a private conversation. If you are unknown to the witness, identify yourself, identify the purpose of the interview, indicate how you came to be the investigator, particularly if, it's an outside person kind of, bridging that gap that, the company has brought me in to look into this and to find out, what happened. Establishing that neutrality, I am just here to find out what happened. That establishing that right up front is a very good thing to do. Again, our retaliation prohibition, that's a key thing. And then documentation. I find it helpful to just explain up front that you're going to be taking some notes. If you are also doing recordings, you want to let them know that, that you're recording. Generally, I just explain, I take notes, but if there's a recording being done, it's because I want to make sure that I'm not missing anything. And I think people understand that. But you may have someone who's uncomfortable. We also want to make sure that we request copies of the documents that the witness has, things that are important to what we're investigating. If they have some documentation of that, it's important that we ask for that and ask for that at the time. If you want to give them a heads up that you may ask for things like that, that's fine. I probably wouldn't. I would just wait and see if it comes up, and then at that point ask for a copy right then. With the fact that most people have smartphones and they have it, and I have an email about that. If they can find that email when they're sitting with you right there, and it doesn't take a lot of time, I would ask right then, can you just forward me that email, and and have them do it at the moment. People get busy, or they get awkward or uncomfortable later, and then you're having to chase them down and get things later. I kind of like to strike while the iron's hot, personally. Confidentiality. We talked about the fact that we can't really promise it. We also can't force employees to maintain the confidentiality of the investigation process. So even though we're having this conversation with a witness, we're doing this interview, it's natural that we would say, we're already saying that retaliation is prohibited. Seems natural to say that you need to keep this confidential. Well, the NLRB is not a big fan of any sort of confidentiality instruction to employees. It's perceived as a Section 7 violation. And in this case, Banner Health Systems, there was a confidentiality instruction. It was actually part of a confidentiality agreement that employees had signed that specifically talked about not discussing investigations and things like that. And the NLRB said that is a violation, and the employer has to establish a need for confidentiality on a case-by-case basis. The next year, in 2013, the NLRB provided guidance stating that the type of language in bold below was an unlawful policy. So the first part of that paragraph that's not bolded is an accurate representation of the issues that an employer can be concerned about for purposes of maintaining confidentiality. But it's that last part that's in bold that is what the NLRB said is not acceptable, but that is unlawful policy language. So you can read that there. It's basically saying we don't do this, we have to maintain it, etc. And says that there may be disciplinary action up to and including immediate termination if someone does not maintain the confidentiality. So on this next slide, same paragraph, same introductory language as the slide before, but the bold language at the bottom is now language that the NLRB says is acceptable. So this is talking about there may be some circumstances that in order to achieve these objectives, which were noted in, previously in the paragraph, we must maintain the investigation and our role in it in strict confidence. So, it's basically, putting this, it's enforcing this case-by-case basis evaluation that the NLRB wants employers to do. So then if we, at the end there, if the company reasonably imposes such a requirement and we do not maintain such confidentiality, then we may be subject to disciplinary action up including immediate termination. So that can be hard to figure out, but if you, in particular, if you've had someone who has, been sharing information inappropriately or purposely trying to sabotage an investigation, those might be some kind of easy ways to look at, yeah, I think we've got that in this case and we should do that. So, as I've mentioned before, that, we may have to ask direct questions, and so we may be providing information. So again, that's why we don't make that promise on confidentiality, is because we cannot keep it. But I will say, and the NLRB acknowledges that there are circumstances where confidentiality is needed, and that's, of course, protection of witnesses, evidence in danger of being destroyed, testimony in danger of being fabricated, and the need to prevent a cover-up. Of course, my argument is, isn't that always a concern in every investigation? And it is. But the NLRB says that just that generalized concern is not enough to support, a confidentiality rule imposed on employees generally. It's got to be this case-by-case basis, and there needs to be some, some indication that this is really an issue. Like I said, we may have someone who's been trying to interfere with witnesses, destroy evidence, sabotage an investigation, that sort of thing. Or there's been some, observations of, retaliation or something like that shows that there is a need for protection. But I would say, even though we have kind of these limitations, I still think it's important that the employer encourage witnesses to use good judgment and discretion. And one of the things that I would just say to them is, obviously if it was you who was having a situation or you were the person who was being accused of something, you would, I believe, not want your coworkers just discussing this. So, encourage you to use good judgment and discretion, and focus on getting back to work and not gossiping generally. So when we're actually conducting the interview, this seems like kind of, I guess common sense, but it can be a little harder because of the awkwardness of the situation. We want to develop a good rapport with the witness. Oftentimes what I do is just defray their nervousness by just addressing it. Just say, I know this is awkward. I appreciate you talking with me. I'll try to make this as painless as possible. And I think people kind of appreciate the fact that, this is an unusual and awkward situation. And by just addressing that up front, I think that can kind of help lessen that a little bit. Maybe discuss some neutral topics. How long have you been with the company? That sort of thing. Or, gosh, I think this project is, great. That it's fun to be involved with, something like that. Obviously, you don't want to take a whole lot of time because you need to get down to the business at hand. But, a little bit of a warm up there might be kind of nice to kind of help, get them settled into the conversation, and then you start, kind of getting into, the topics that you need to cover. Again, we want to reiterate, it's important that every witness understand that retaliation is prohibited. So it needs to be said with every witness. A lot of times I will mention it twice, once at the beginning, once at the end. Or if a witness is worried and starts saying, I think I'm going to get fired because I talked to you, then of course saying it at that point. This cautionary statement that I've got on this, however, injecting it repeatedly and unnecessarily could have the opposite effect. It can. So we don't just want to say it often just to kind of check that off the list that we did it. Make sure we say it, because we need to, but repeating it without any need sometimes can actually scare a witness that, oh, retaliation. I mean, we're putting it back on the radar screen. And if it's on that radar screen more than they already had it on, that seems to be a little much. So that's just a kind of a practical issue I've seen, kind of happen. So when we're conducting the interview, we start with the open-ended questions. So that we start with a broad topic and then we kind of winnow down. So the example, it's my understanding there was an argument in the workplace last Friday. What do you know about that? Instead of, did you see or hear Dave start an argument with Joe? Kind of a subtle difference there, but, a key one. So we are not, asking them to, kind of confirm what we've already heard. We're asking them for what their observations were, because there might have been more to that argument between, Dave and Joe. Perhaps, Joe whispered something to Dave that that not everyone heard, and and then Dave, came back louder. The incidents like that, where there's sort of a one incident or kind of an explosion in the workplace where there hadn't really been a lot building up, those are usually a little kind of easier to get your arms around because lots of people witnessed it. There's kind of a mark in time where we know what happened or we know something happened. What's a little bit harder is when you've got an allegation that there's been ongoing discrimination, harassment, kind of the building of a hostile work environment, because it's a longer time span. And so that's where, we'll often have, the broad topic and then winnow down. So what was going on? My understanding is that there's been some tension in this department for a while. What have you observed about that? Some people will just lay it all out there and give you everything, and you may have some follow-up, and that's fine. But, a lot of times people are nervous, and they're not exactly sure what you know and what you don't know. To some extent, they might be uncomfortable with the language that was used. So it's not that they're trying to hide anything, but they don't like saying those words. And so they might just kind of give you very general responses. And then you have to, really get specific with them. Also, as part of the, when we're talking through kind of the more neutral topics and kind of the introductory, make sure that you're observing their eye contact, their tone of voice, their demeanor, their body language, that sort of thing, because that kind of helps you set that baseline. And then when you're asking, kind of these, open-ended, broad questions, you can almost start to see people tensing up when you're getting closer to, the piece of information, perhaps that they are uncomfortable sharing. And again, it might not be that they, are trying to be deceptive. It could be that they're being deceptive. It could be that they're just uncomfortable with the subject matter. So you can start to see, if you're observant, a lot of times you can really start to see the person getting tense, and then you can tell, or their voice gets higher or tighter or whatever. You can tell that maybe you're getting closer and closer to something that they are uncomfortable with, and likely might be part of the key information you need for the interview and the investigation. So when we're dealing with a complainant, full, fair opportunity to provide complete information, all information they have. It's important when a person makes a complaint that we let them provide as much information as possible. We do not want to look like we, overlooked anything or didn't care about information they wanted to provide. Now, that being said, they may want to provide information on a lot of other things that are irrelevant. So there will be times with a complainant that you may have to say, now, is this related to your complaint? And they well, no, it's really, I say, okay, it's not that I don't want to listen to you, but I'm focused on this issue. So, just for, your time, I want to make sure that we really get all the information out on the issue that you raised in your complaint. And they understand that. Some witnesses are harder to keep on track, but, just kind of keep relating it back. Prompting. Some witnesses are a little harder to get information from for various reasons. So you need to, was there anything else about that situation that you thought was unfair, harassing, inappropriate? Just kind of keep asking those follow-up questions, prompting them to provide all information about each incident as it happened. We want to make sure we get other witnesses from the complainant. Who else do you think can provide me information with regard to, these issues that you've raised in your complaint or these issues that you've identified during our interview here today? One thing that it can be a little bit tough is sometimes a complainant will give you a long, long list. And what I will say is, okay, who has the most information? And who on this list would have the same information as other people? To kind of start to winnow down a little bit. I will just ask the complainant that and just say, I want to talk to, I want to find out as much important information about your complaint as possible, but I might not be able to get, every single one of these people interviewed if it's a long list. Which ones are the key ones that you think are important? First of all, the complainant has a lot of the key information, so they should be able to give you, the key witnesses. So that's helpful to you in winnowing down, your witness list. But also, the complainant feels invested in your process and that you're being fair. And so that is helpful too. It helps with the credibility. And then, on the back end, if you're ever challenged for not speaking with witnesses, say you're being deposed or cross-examined in court, here's why. I talked with the complainant, and they really thought that this person would not have any new information than these other three who I was already talking to. That's how I decided not to speak with them. It takes a lot of the sting out of not speaking with the witness. So there are, strategic reasons to do that with the complainant. And then at the end, it's very important with all witnesses, but particularly with the complainant, to close the loop. Is there anything else you think is important for me to know as I do this investigation? Make sure that, there's not anything else that, they're sitting on that they should be telling you. Well, you didn't ask me that question. Sometimes people will kind of play a little bit with, well, you didn't ask that specific one. Well, when you ask a question like this, you're covering everything. And then, like I said, I like to do a reminder on retaliation then at the end. Respondent, same thing. We want them to be able to give a full and complete, response to everything that's, being raised against them. We also want to see if the respondent has other witnesses and kind of go through that same process. Same thing with the respondent, close the loop. Is there anything else you think is important for me to know as I do this investigation? And I word this question in a way such that it's not just the witness's observations, because some witnesses are very specific. Well, I didn't see that, and I didn't hear that. I've only heard other people talk about that, so I can't really be a witness on that. Well, I try and word it differently so it's, what is important for me to know about this? And that's where you might get additional information like, well, these two, their kids went to school together and the kids got in a big fight and these families hate each other. Okay, that's not something that was observed in the workplace, but that might be an important factor to understand why these two people are not getting along well. So just, some tips like that can be helpful to kind of get additional information. And also with, the respondent, reminder and retaliation. Of course, other witnesses, same thing. And in fact, they are oftentimes very nervous about retaliation, almost as much as the complainant is, sometimes more than the complainant is. So it's important to make sure they understand that. And a lot of times employees realize if they make a complaint, they may have some protection. They may not realize that just participating in an investigation gives them some protection too. So like I said, sometimes they can be more worried about retaliation. With other witnesses, oftentimes we've gotten this information from the complainant or the respondent. Well, so-and-so will say this. I prepare a list of bullet points of issues that I want to make sure I cover with specific witnesses based upon what has been reported to me from the complainant or respondent. And then that way I make sure I'm, covering those things as I'm doing, my questioning of witnesses. Again, with these witnesses, they may not know as much as certainly the complainant or the respondent. Open-ended questions are really important so that we're not, providing them new information to now go possibly spread around the workplace. But like I said, sometimes you really do have to get down to the specific question because they're not going there with you. And the answer might be, no, I did not see that. I did not hear that. Okay, well, you've got the answer. And that happens more often than you would think. I will have, a complainant or a respondent say, this person will say X, and they don't. Is a written report needed? It's not a legal requirement, but it can be helpful. Again, one of the purposes of this is not just kind of resolving the workplace, conflict, which is important, but it's also a defensive mechanism if there is litigation. Having a good written report can be helpful. Even if we don't have a written report per se, it's a good idea to have some sort of documentation that the investigation is complete and what was done by the investigator, what the findings were, and then what, if anything, was done in response to the findings. And that might be, someone's disciplined, terminated, whatever. That can be documentation of what was done in response to the investigation. I have had situations, even just
And I think we had you drop off again. Just sign out and then sign back in real quick. Thank you. While we're waiting for her, I'll just go ahead and go through the announcements at the end till she comes back on and can finish. Here are your HRCI and SHRM codes, so you can go ahead and write those down now. And can you hear me?
Okay.
All right.
Can you hear me?
Yeah, we got you back.
Okay, great. Sorry about that. So we want to make sure, so I asked two questions. One was, some specific factual, and then the second one was, did you find that there was any illegal behavior or, actionable behavior on behalf of the president of this company and the company itself? We've had a question, is there any merit in asking the complainant what he or she considers a resolution? That's a great question, and I would say yes, and I oftentimes do it. Now, the only caution I would say is you want to make sure that you are not promising anything, and so, you just word it in such a way that is, indicating that, obviously I'm just here as an investigator, but one of the things I'd like to find out is, what are some things that you think would help fix this situation? That's something I'd like to report back to the company so that, we can they can consider some options and things like that. I think that's a great idea. Also, from a strategy standpoint, If it's a very simple fix and the company does it, it's a little bit harder later, for, that employee or their attorney to say, you should have done X, Y, and Z. This was so awful. You can point to the fact that, well, this is what the person thought would be helpful, and, we did that. So it's good strategy, and I also think it helps the complainant feel like, they are part of this process and that someone is listening. Just be real careful to make sure that you're not, promising anything, or that they think you are promising something, because I know that you wouldn't. So we want to make sure that we are, talking with our legal counsel to determine what, if anything, is going to be needed. Again, a written report or anything in writing, like the questions that I did, it's all discoverable. So if there is litigation, it would need to be turned over. So we want to be careful about that. And that on that last bullet point, documentation that's done poorly can be worse than no documentation. Had a question, can the interviewee be allowed to record the investigation? I think I have allowed that. My only concern is you want to make sure that if they're recording it, then you should record it. Because what I don't want to have happen is that someone does a recording and then they can alter it. So if they want to record it, then I would make sure that you record it too. Another note on documentation is, as you're taking notes, you have sort of your factual notes that are responding to the questions that you're asking, the information that's being provided. But then you are also doing a credibility assessment of these witnesses. And I would say I would not put your comments on a witness's credibility in your factual notes about the interview. That I would have as a separate, it can be the last page of your notes, but I would have it in a separate category in that time after you complete the interview with that witness. As I said, I go back through and kind of fill in the holes and kind of make my notes more complete while it's still fresh in my mind. Then I think about, the things that made them seem more or less credible, and I will put that in a different section. And the reason why I put that in a different section is if you make that part of your notes where you're getting the factual information from them, it can be used to say, oh, well, you thought this was a credibility issue, so you really just stopped believing them here on page 2 of your notes. And that's not the case. It's a cumulative effect about credibility. So, but that's why I just do it in a separate portion of my notes. That's my credibility assessment there. And again, like I noted, you want to look at, how did the eye contact, how was that? Some people are terrible with eye contact, but that's how they are all the time. But if they changed, so for example, if they maintained good eye contact and then stopped, that's something to take note of. Changes like that can really be cues in, in that credibility assessment. Now, just because someone's demeanor or eye contact changes does not mean that they are necessarily lying. It may mean that they are very uncomfortable with the subject matter, and they might be uncomfortable because they're lying, but they might be uncomfortable because, they feel very upset about what happened. If it's a sexual harassment type situation, it could be that this was, very embarrassing, very personal. We don't really know why, something might be traumatic to another person. We're not mind readers. So, we're looking for changes in demeanor, and it's good to record those in your credibility section of your notes. But I would also be careful to assume that that a change means deceit. Just look at all the cues, look at all the circumstances. One of the things that I also look at when I am speaking with witnesses is, do they ever act in any way that's self-deprecating? Or is everything always someone else's fault? Are they ever wrong? I mean, if you have a witness who is never wrong and everyone else is, I think that shows this person may not be terribly credible. It does not mean that they are necessarily lying, but it does mean that they certainly have a perception that is somewhat skewed because we all make mistakes. We all do something wrong. So there can be some things like that that can help you kind of decide, uh, you know, some of those credibility things. I also like corroboration. Sometimes it's very hard to, when you've got a he said, she said, whatever, it can be very hard to just pick who's right and who's wrong. And you may not be accurate, by the way. We're not, like I said, mind readers. We don't know, but we do the best that we can based on the information that we've got. Factual corroboration can be, and this is not rocket science, that's very important. And so the more that you can kind of stack up the pieces that seem to line up with the complainant versus the respondent, that in and of itself can be helpful. So, for example, if the witnesses seem to track more consistently with the complainant, even though maybe no one saw the ultimate, incident that happened between these two, if they tended to track more consistently on all other factual things that can be corroborated, that should help play into your assessment. We have a question about, is the written report needed? It is not necessarily needed. I think it is very helpful, but it's not a necessity. I do think you want some sort of documentation, like I said, whether it's a couple of questions to the investigator confirming the results, or a copy of course, their file too. Might be something that your legal counsel would want to maintain. Let's talk a little bit about the file. It should tell the story, the complete story, not only the complainant's story, the respondent's story. It should tell and show your story of how you handled this whole investigation from beginning to end. It shows your organization. It shows the different steps that you took. It shows how you cataloged, the evidence, how you kept track of notes, etc. And then if you do have some sort of written conclusion, it'll show that as well. It shows the consistency. You handled, each interview as consistent as possible. There might be some differences, but be able to show why those differences happened. So if you had a witness say, I don't want to be recorded, note that in your notes. This witness did not want to be recorded. Well, then you know why that one doesn't have a recording. It wasn't lost, etc. It was because of that reason. And it's organized. You can find things. Someone who picks up that file can flip through it and kind of understand what has happened and what you did and how you should hopefully track with how you came to the conclusion that you ultimately came to. So let's see. I think we've gotten to the questions that had been put up already. If there are other questions, please make sure to go ahead and post those now. Otherwise, I think Eric's got a few closing remarks, unless you got to all of them when I was offline.
Yeah, I think we've got all the other questions. If any more come in, we'll try to get to them. I think we've gotten to all of them so far, though. Really appreciate you coming on, Ann. Great presentation. I'll just go ahead and put up again the SHRM event ID and HRCI activity ID. I did see we just had a question come in, so I'll throw that to Ann. Stephanie from South Carolina asked, what do you say to the complainant when the investigation is done and the result is neutral?
And that is a great question. What I will say generally is that we've concluded the investigation. We were unable to establish that there was, and it kind of depends on what the situation was. We were unable to establish that there was any illegal behavior. We were unable to establish that there was a violation of the policy. That does not mean that we do not believe you, but we had to look at all these different pieces of evidence, and it either appears that this was maybe unprofessional behavior, or it might be a violation of sort of a workplace policy, not the harassment policy, but sort of a, kind of a good citizenship policy, that sort of thing, but not something that rises to the level of illegal behavior. But I would then tell them, again, thank you for bringing this to our attention. We are going to take some steps to help, not have misunderstandings or conflicts like this get to the point that, someone is, so frustrated. And of course, you should not be retaliated against. If you feel like that is happening, immediately come talk to us. So you do, establish the fact that you want them to bring issues to you or to the company. That it's not that they are disbelieved, but that based upon the weight of the evidence, here's what we found is maybe we've got a professionalism issue, but it's not something that was illegal. But the company is going to take some actions to try and make things work better, and to feel free to raise issues again in the future if they see any.
Thanks, Ann. Again, if you have any other questions that you think of after this, there's Ann's email and my email as well, so you can email either of us, and we'll definitely help you out. Like we said, we'll get everyone a recording and slides from this webinar by email, with Monday being Labor Day, Tuesday at the latest, we'll have that to you. We hope you'll join us for our next webinar, which is on October 8th. Switching gears a little bit into more of a safety-focused topic with a really good speaker as well then. We're also offering everyone here 10% off anything on hrsimple.com. So you can write down the code SEPT webinar if you would like to buy anything and get a little discount. And there's the SHRM and HRCI activity IDs once more. So I don't see any more questions coming in, so I guess I'll go ahead and wrap it up. I want to thank Ann again for coming on today. She gave a great presentation, and we were happy to have her. On behalf of hrsimple.com, BrownWinick, and the Iowa Association of Business and Industry, thanks for spending time with us today. We hope you'll continue to learn with us throughout the hrsimple.com webinar series.